warahmatullahi wabarakatuh. My name is FATIN NURJEHA BT SHAFIE. Membership number 1190825. So for today, I would like to present my study case for this subject. First of all, I will begin my presentation with law of contract case. This case is between the plaintiff, Mr. Yong Eun Kai, and the defendant, Mr. Tuai Rumah Enteng. For summary of the fact, it can be concluded that this is a sale contract of timber between Mr. Tuai Rumah Enteng and Mr. Yong Eun Kai. This agreement was signed on 25 September 1962. The timber was sold to Mr. Yong Eun Kai for $22,000 for 3 installments. The agreement gives Mr. Yong Eun Kai a right to cut, extract, or sell the timbers on the said land. According to a land code, to work the timbers, Mr. Tuai Rumah Enteng need to have a legal permission or a permit from Forest Department. Unfortunately, Mr. Tuai Rumah Enteng was failed to get the legal permission from Forest Department as it was a refusal from the Forest Department. This make the license or legal permission was given to another party, which is Hua Sin Swamel, and the defendant received $4,000 for giving Hua Sin Swamel a right to work the timbers on the said land. The first issue is the issue arises when the defendant failed to get the permission or failed to get the license from Forest Department, as it was a refusal from Forest Department. Secondly, the plaintiff alleged the defendant for breach the contract between them. Thus, he claimed the defendant for expenses and general damages. Next, judge's decision. For the first issue, based on the judge's decision, the plaintiff claims for breach the contract is failed because legal permission was refused by the Forest Department, and the defendant has tried to get the legal permission from them. Second issues, based on the judge's decision, the judges entitled the plaintiff monies that has been paid to the defendant before the agreement was discharged. The judge held the defendant to repay the plaintiff for general damages. This is because, according to Law Reform Act 1943, all sum paid or payable to any parties in pursuance of the contract before the time parties were discharged shall be recoverable. This make the judge held the defendant to repay the plaintiff for general damages about $2,585 and $1,000 for earlier payment after the signed event. Next, I will continue with sale of good case. So this case is between the appellant, which is S. Tilaimutu, and the respondent Ong Hook Lim. For the summary of the fact, this is a sale contract of 100,000 tiles and 2,000 reach with Ferox size. The respondent was misunderstanding about the tiles and reach size, that saying as a first-class roofing tiles and reach with Ferox size. Besides that, another rejection letter that wrote by the respondent solicitor on 9 June, but unfortunately, it cannot operate as rejection as the goods have been received by the respondent and he has delivered the good to a sub-purchase in Alostar. For the issue, there is one issue that lists in this case, which is The issue is whether the respondent have accepted the consignment with the appellant or not. For the judge's decision, judges held the respondent dealing with consignment is constituted as an acceptance. Because of that, the respondent lost their right to reject the consignment and they were confined for the remedy damages. The reason for the judge's help is because the respondent has accepted the goods and the respondent has delivered the good to the sub-purchaser and in Alostar. Lastly, I will proceed with hire purchase case. This case is between the appellant SP Chandra 4 and the respondent Li Leng Guan. For summary of fact, this is the agreement of hire purchase contract for a car with the appellant company. Based on the appellant statement, the respondent failed to pay 2 installments that cost about $659. The appellant issued the notice under Section 15 of Hire and Purchase Act to repose the car. According to the respondent, the possession of the car is illegal because there is a doubt about the notice. There was 2 registered letters that sent to the respondent addressed in Johor Bahru. The first registered letter is a notice under Section 15. It was sent from Melaka in 1st March 1975. The second registered letter was sent from Johor Bahru branch after 1st March 1975. Normally, if the notice has been sent, there is no requirement or compulsory to send another registered letter to the respondent. According to the second appellant or DW2, he admit that he did send another registered letter, which is the reminder, to the respondent after 1st March 1975. This support that the first notice which is sent on 1st March was not reached to the respondent. Another fact that support the respondent argument is minimum statutory number of days. From the notice, the date was specified for on 20 March 1975 for the appellant to repose the car. In fact, the car should be reposed on 22 March 1975 because according to Section 15 in Hire and Purchase Act, the period of notice shall not less than 21 days after the service of the notice. So there is 2 days short for statutory minimum number of days. There is 2 issues that have been found in the case. Firstly, doubt regarding the notice under Section 15 from Hire and Purchase Act, either the notice has been received by the respondent or not. The second issue is failure of the appellant to comply the statutory minimum number of days in Hire Purchase Act. For the judge decision, the first issue, the judge held the default from the appellant in issuing the notice because based on the evidence and the declaration from second defendant, the respondent did not receive the notice on the specific time and place. For the second issue, the judge held the case in his favor, ordering the car to be returned as there was appellant default. Because under the Section 50, it clearly specified that the period shall not less than 21 days after the service of the notice before the seizure could take place. However, the date specified in the notice was 2 days short of the statutory minimum number of days. That's all from me. Thank you.